afternoon and welcome to today's Broker University webinar. Arizona Realtors is proud to bring you this monthly webinar series designed exclusively for our brokers to learn fresh insights on current topics. I'm Callie Waterhouse with the Arizona Association of Realtors, and today's webinar is Titleman's Top 10 Tips on how to handle mechanic lien issues. And you can say that 5 times fast. You are doing better because I had to practice it. So today's webinar is with John Lotardo, aka Titleman. And John is the State Counsel for Arizona and Nevada and Senior Underwriting Counsel for First American Title. He's a licensed attorney practicing in all aspects of real estate, title, escrow, corporate operations. He's an active member of the State Bar of Arizona, a speaker, instructor. He's an expert, a guest commentator. I know that he just completed his tenure with A.R.S Residential Contract Work Group. And I know that he's done some great stuff for the ADRE as well. And today's webinar, John's going to be speaking for about 40-45 minutes on the very riveting topic of mechanic liens. And I actually had to practice that several times. Riveting, get it, mechanic liens. So if you have questions, for those of you who sent your questions in earlier, thank you very much. At the end of today's webinar, we'll be taking questions for about 10 to 15 minutes. As you know, if you've joined us in the past, today's webinar is being recorded and will be available on our website at aaronline.com. And when you're done with today's webinar, there will be a survey for you to fill out. It's like 10 easy peasy questions, just letting us know, did you learn something today's webinar that you can easily implement into your business? Was there something you were looking to learn that we didn't cover? Always, your feedback is definitely appreciated. So with all that being said, a great big humongo welcome to John Lotardo.
Oh, thank you very much, Callie. I really appreciate you having me here today with all that build-up regarding construction law and mechanic liens.
Yes.
How's that for a pun?
That was pretty good.
Thank you very much. This is actually a perfect presentation to be doing right now for the industry. We are coming out of that big recession that we've had for a number of years. And we've come up with this great opportunity now of coming out of that and starting to grow, to build, to sell. And so it's actually going really well to have this as a time for us to be presenting right now. So today's topics are going to include some of the, really the practical tips on how to handle mechanic liens, what these are. We're going to talk about what they are. And why is it different than other types of liens that we see on real estate? And how they're going to affect insuring title. As we had talked about, I'm from a title company, and we deal with title insurance. And one of the critical issues is obtaining title insurance for your clients, whether your clients are a residential consumer, a commercial investor, a lender. And so one of the critical pieces is how mechanic liens are handled from a title insurance perspective, so we get those taken care of for you and get the title insurance that you need for your client. So we'll talk about those impacts on title and then what we need you to do or what tools you can have in your arsenal so that we can get a successful closing for your client and for our mutual client. So that's what's going on for us today. And so as Callie had mentioned, we do have a Titleman's Top 10 countdown. Just rolls off the tongue, I think, right?
For you.
Okay, well, maybe not. But I did that deliberately just to bring a smile to your face, so it worked. So let's start off with number 10. What is a mechanic lien anyway? So really, mechanic liens is just based upon statute. Arizona Revised Statutes, you've heard of it, provides for liens for those who supply labor or material. That's the short version of what the statute says. It's in the statute. It's in section called Section 33. And you can always Google that or go to the legislative website and get those statutes. And there's a whole bunch of in there. They change regularly, so keep an eye on it. But we're going to talk about some of the major points and some of the current nuances for you. But keep in mind, they do change every once in a while, and I know we try to fine-tune them, especially over these past couple of years. But yeah, so a mechanic lien is one that deals with those types of rights where someone is actually supplying material or doing work on the property. And when they don't get paid, assuming they've complied with certain requirements, they have a right to lien the property. So until they get paid. And so we'll talk about what that is in a minute. So let's talk about how different this is than other types of liens. Well, for other types of liens, we're used to other ones, right? We're used to a mortgage or a deed of trust, typically a judgment lien, say, for example. Well, a lot of those are ones that have what I would call normal type of priority, where they basically have established when they have their priority based upon when they've recorded. So the priority issue is something that is sometimes different when it comes to mechanic liens because of this terminology called broken priority. And let me talk about what broken priority means for a second, okay? Because you may hear this, and a lot of lawyers and a lot of title people talk about this, and we really don't define it very well for people out in the field. And so broken priority is something that's very particular to mechanic liens, or the construction liens, or whatever you want to call those. It is when the priority that you're used to, the first thing that's recorded is the one that has priority. The second thing that's recorded has second priority, and so on. Your first, second, third priority of record. Well, if you have broken priority, guess what it sounds like? Priority has been broken, meaning the priority that we're used to, first, second, third, and fourth, is all jumbled up. And so the concern is to try to translate, what does that mean? Well, the whole issue is if we're insuring a loan and we have broken priority, sometimes the loan that's recorded today may have lost its priority to some work that was done. And it gets complicated from there, but the issue here is if you're dealing with any sort of work on a piece of property, these kind of questions are going to be ones that the lawyers are going to be talking to the title company about. And they're probably going to be talking to your client about it or with the lender. And so the real issue here is to consider if you have work being done or going to have work being done or material being supplied, this whole question about are there mechanic liens? Is there mechanic lien possible? Will there be mechanic? I mean, all of those kinds of questions are going to start being asked in the background, and you may hear about those. Now, no one's expecting you to have all the answers, but you are going to be a critical piece to make this a successful closing for your client. And that's really the purpose of this webinar today, is to help give you some of those tools so that you feel comfortable in participating, in understanding some of the basic concepts, so that we have a successful closing and a happy client and no issues down the road. That's the goal here. So going into number 9, so continuing on. So the first off is the current situation that we have a mechanic lien recorded, or just that we have broken priority. Well, I put just in parentheses or quotes, excuse me, because the question is up there, is that better or worse than if a mechanic lien actually recorded? Well, keep in mind this issue about broken priority. If the discussion is going to happen, the discussion will have occurred whether or not there is a mechanic lien recorded, meaning if someone has not been paid during the transaction or before the transaction, whether or not something has showed up of record. If there's a discussion about this is a construction loan or materials being brought in, or it's any of those types of issues, you're going to have that conversation whether or not a mechanic lien has recorded. Now, I will tell you, if you have a mechanic lien recorded, that is sort of, worse is a tough word to say. It gets more excitement, shall we say, if a mechanic lien has recorded than if there's just a discussion about the risk, because the cat's out of the bag. The barn door is open. The issue is no longer in theory, it's actually an application. So although many of the same questions occur, there's definitely a heightened urgency and more important issues to discuss when you actually have a mechanic lien recorded. So we always would prefer no mechanic liens recorded in the discussion, but if they are, that is just another facet of us to address. So, that's just one of those things that we have to deal with. So, talking about dealing with it, number 8, how do we deal with broken priority issues? And so that is the next topic of how do we apply this on like our day-to-day when we're dealing with these questions. So from an underwriting perspective, we have certain types of requirements, and you may hear about this, and they include these various items that you'll see up on the screen today, which are the evaluation of the risk and the review of particular circumstances. So these are, and that sounds like a generic underwriter type of call, and I will tell you, yeah, that's where it starts, believe it or not. And there's a lot, we'll go through all of those types of items that we're evaluating in just a moment. But these types of requirements ebb and flow. We went through a number of years where we had to recover from adverse mechanic lien issues over the recession for a number of years. And before then, we had a lot less issues to deal with. And so we are basically going through that ebb and flow. And so it changes depending upon which underwriting group you work with or what circumstances are. So it's very file specific, very fact specific. And that's why you'll see that you'll probably get a lot of discussion about this. And so you who are out in the field, you're going to want to know if there are any potential risks here, because you're going to want to start getting your client alerted or basically get them on board with the idea of working with their escrow agent of choice, title company of choice, to work through these issues to make sure that they've been satisfied, those kind of questions have been satisfied, to make sure the lender is satisfied, all of these types of issues. So let's get into some of the things that, that people will be investigating, like myself, when we're evaluating these. And it's not always on the same one all the time, but these are some of the basic things that you'll probably get questioned on or asked that the clients participate or have the lawyers participate in. And I first start off with the first one, which is inspection reports. Okay, inspection reports. Pictures say 1,000 words. I know that this is a audio only, but if I had thought about it, I would have given you many more pictures about what looks like broken priority and what doesn't, but you can imagine when you have a half-built home, if you have some property where you have a bulldozer on there in the middle of bulldozing a portion of a building down, if you have carpenters there on a site, any of those types of pictures, a lot of times people like myself, we're not out there at the site. It could be remote. It could be in a different county for all we know. And so one of the first things that I question about, what is going on out there on the piece of property? And sometimes that helps to alleviate the questions about that I may have, where someone says, oh, John, you don't have to worry. There's no broken priority. There's no mechanic liens. You've checked the title record. There's no mechanic liens, and there's no broken priority because there's been no work and no supplying. Well, what's one of the easiest ways to establish that none of that is happening as the clients told us? A picture, right? And so some of the requirements is to get a picture, get an inspection to establish that no work has been done on a property. And so, like I say, that's a great place to start. So a lot of times I like to see pictures. And sometimes if those can be provided, during a transaction or right at the end, that's helpful. You don't want to talk about it right at the end. You don't want last minute surprises. I should start off, since we are talking right at the beginning, is we don't want to have broken priority. You don't want work to be done prior to a transaction closing, say, for example, if you're going to be putting on a construction loan. But sometimes you can't avoid it. For example, many of you probably handle transactions where a seller has built a building and a buyer is buying that building now that it's complete. And so the work, you can't not have the work done because that's the whole purpose of the buyer buying the building. And so you will have broken priority, but one of the questions is, what does the picture show? Are they done? Picture shows 1,000 words. Have they completed the construction? Just so we know how much has been done, how much has not been done. So that's why I like pictures. I'm a visual guy, and so, I mean, I know I have to deal with a lot of numbers and technical stuff too, but that helps get me through there. And so a lot of times, understanding the status of the property is helpful. Now, sometimes it's a little confusing, and sometimes I need someone to explain it to me a little bit more about the transaction. I talked about a second ago that, well, maybe it's a seller that's building a building and a buyer is buying the building. But most people in the real estate community realize that transactions aren't always that straightforward, right? Sometimes we have a variance of that where the seller's building the shell and the buyer is building the internal improvements for themselves, or who knows, any number of things. So one of the questions is, sometimes the pictures are not enough. And so we're going to want an understanding or an explanation. May not need that on a more traditional, smaller project, but on these bigger projects, sometimes I'll ask a narrative to be done. And sometimes there's consultants involved in transactions or lawyers, and they're able to identify it for me. Sometimes if it's a complicated lending situation, maybe the lender group can explain to me what's happening. And so sometimes a written narrative or a call, at least, gets me over that so we understand what's going on, so then we can work with you out there in the field with the client and the customer to assemble some of the other material we may or may not need. Sometimes we don't even need anything else beyond some basics, but sometimes we do. And that gets us to the next page of some particulars. Now, I said before that I like pictures, but sometimes I also like dollar signs. I like to see financials. And that's one of the things which is the most difficult sometimes to obtain. Sometimes it's not easy to obtain financial data from the client because of, in today's world, everyone wants to keep certain things private. That is one of the things that everyone, obviously throughout the industry, understands the importance of privacy when it comes to financial data. If it has gotten to the point where some financial data from somebody or regarding the property is needed, you could always ask why to make sure that that really is needed. But usually, for example, someone like me who's evaluating mechanic lien risk will look back and say, well, financial review is probably important for us, just like with the lender doing financial review of the project. And so be prepared to have a discussion about why financial information is needed in a transaction regarding mechanic liens. And financial review, and let me try to answer my own question is, well, why is it even important to know? And that's a good question, John. So really is we want to figure out a few things. What is mechanic liens about? They are about when people don't get paid and they're filing liens to protect their interest. So go to the first part of that sentence, when these parties are not getting paid. So the financial review of financial data, we can talk about what that is in a minute, financial data helps to establish, are we going to have problems with these contractors or subcontractors or suppliers or material? Are we going to have problems with them getting paid from X? And the financial review would be able to help confirm, no, we're not going to have problems because they've already put something in place, they're good financial backing, they have contemplated this project or this house or whatever the issue is. And so that's some of the evaluation that's being done, not only by the title company, but by, for example, a lender loaning money on a construction loan, for example. So those are the questions behind a financial data, and it all depends what type of project you have will depend upon how complicated those questions will be. Sometimes the question is real easy. Sometimes it's much more complicated depending upon the project. If you have a big multi-million-dollar project, you'll probably have more questions than if you have a single residence, which has already been built and it's owner-occupied, and it should be easier. And those are some of the nuances that you may hear that, oh, well, so-and-so didn't need this the last time I dealt with broken priority mechanic liens. But in this current transaction, I'm having to evaluate this, and I'm answering a lot of questions from a bunch of lawyers, having to interact with my client more, and they're very frustrated. And it all depends upon the type of project and where the stage of the project is. So financial review, important. Depends upon what kind of party. The SPE, that, by the way, single purpose entity, that's very in vogue. You hear about that a lot, where you have a single purpose entity who owns property or is about to own property or is starting a project. And depending upon that type of entity structure, that means that single purpose entity is basically an entity that was created specifically for this piece of property, for this project. And so that's a little bit more limiting, shall we say, than if you had a corporation that owns many properties or is over many states, or individuals like you and I who own property in our own name, that have our own bank accounts, our own stocks, our own, etc. So depending upon the project will depend upon which financial data the title company or the lender would be reviewing. So those are really some of the things that will be more flexible depending upon the project. Appraisals, you've heard about these appraisals, right? Sometimes the transaction do or dies based upon appraisals from a lending perspective, right? You have to address those issues. Well, the same thing, valuation. Does the appraisal establish the amount of equity in the property that the owner has or will have? Does it establish what the end value is, such that all of the work that has been done or will be done on the property is justified? I bring that up because you would think, well, that's common sense. Of course, you're not going to put $1 million in a piece of property and it's only worth 700. Well, that is not always the case, because I dealt with this on more than once or twice or a few occasions where the appraised value is going to be less than the ultimate construction. I had one from some time ago where they would be spending significantly more, $1 million more on a piece of property because of all of the specialty features. Not all of us have the same taste. And so as a result, in this project, they were spending more than typical, to such extent that it could never be recouped from an appraisal perspective. And it was so unusual that was causing problems for people to underwrite this loan, to fund the loan. And so appraisals is a starting point to get an idea. Remember that whole idea of a picture? The appraisal is sort of a picture of the property, but from a valuation, from a numbers perspective. So another picture idea. I like to get a picture on what that property is going to look like. And, there's different appraisals. You got an as-is, versus an as-complete, versus as-stabilized. That's all the lingo that the appraisers use. We are very grateful to the appraisers in the industry that establish these values for us and get us this information, because it's very helpful for us to understand what we're doing. And then the last one on the screen there you see is regarding bonds. And bonds are some form of protection against mechanic liens. And there's different kinds that are out there. Sometimes you hear, oh, well, let's just bond around it. There's payment bonds, performance bonds. They're all set up through statutes. They all go through some form of surety, insurance type of company. They are somewhat sophisticated to get. Some projects require them. There's certain projects when you're dealing with like the government or what have you, they'll require certain things to happen, whether it's a city or the feds or what have you, where they'll require these bonds to be put in place. Does that eliminate all the risk? No, not exactly all the risk. And I mean, they're limited to certain types of protections. But I certainly would say if they're in place, is that helpful to alleviate the risk? By all means, yes. So if you are aware that there's a payment or performance bonds on a project that you're working on, you definitely want to get that information to the attention of the underwriter, whether it's the lender or the title company or what have you, because payment and performance bonds are good to know that they're out there because they are a form of protection that is helpful for us to know about. Let's get to this next one, which is what I'd call pen to paper, the indemnity or indemnities, and then from who. See, this issue for an indemnification is one of the other sensitive topics that we have is who will be basically indemnifying or protecting either the title company, the title insurer, or sometimes there's some affirmations or guarantees made to a lender, for example. So if there is a broken priority scenario, there will be discussions regarding an indemnity and who's signing it and who's not signing it. Those are discussions that the client is going to have. And guess what those indemnities or who is going to sign those indemnities is based upon? It's going to be based upon the material that we just talked about, right? The financial reviews, the appraisals, the bonding, those types of issues. There's a lot more of a review that's done from the underwriting perspective regarding construction costs and how lien waivers are handled. We'll get into lien waivers in a bit. But once we've gotten to a point, we want to figure out who is the proper party to be signing an indemnity. And those are those documents that you'll see that are being circulated during a transaction. And one thing I'd want to say is these conversations, you should try to have them as early as possible in the transaction. Why? Is because they take a while to get people to understand the dynamics of this issue. We certainly understand last minute items like we all do in a real estate transaction. It happens all the time. But if you're aware that you're dealing with a construction loan or broken priority matters, you're going to want to have those conversations early and upfront with everyone to make sure everyone is on the same page, that everyone is moving forward to the ultimate conclusion or resolution, which is what? Closing the transaction and doing the insurance like the parties want to be done. And so make sure we're all aiming for that focus, that end date, that closing successfully. And so that's why these discussions about indemnities and who's signing them should come earlier rather than later, especially even for availability. Sometimes you have people who are supposed to sign indemnities and they're not even around because of circumstances. We notoriously have that problem, obviously summertime or holidays. So you're going to want to anticipate that. Who's going to be around? Who do we need to sign documents? All right, so now we kind of got through all of those types of issues. Say we've gotten comfortable or we're kind of all have bought in to this idea of what needs to be done on a transaction. When it's broken priority, we've supplied material. Now I start hearing these other conversations around the parties. And you start hearing these discussions regarding incremental exceptions or incremental coverages. Some of the questions is, well, what does that mean? Well, one of the discussions that has come up in the market is this idea of giving incremental coverages to an owner or lender based upon the stage of the construction and the disbursement. It's different. This would not apply really when you already have the house built, right? It's already all done. The money's already all been dispersed. You don't have that in this conversation. What we're talking about is at the beginning of the transaction, the beginning of the construction loan, for example, when monies are just starting to be dispersed by the lender and the building or the home is just starting to get built. And so some of the discussions regarding coverages from a title insurance perspective is what are the parties comfortable with accepting? And so a lot of times you'll have discussions between the lawyers about, well, maybe we can give some sort of pending disbursement coverage to a lender. And what that means, just if you've heard that conversation, it's basically discussions about what kind of incremental coverage can be given to the lender such that as they're dispersing money in a certain way, their coverage under their title policy goes up. So say, for example, you have a $3 million loan and they haven't dispersed. They're dispersing in, say, 10 draws schedules. First this, and then a couple weeks later this, and then a few months later this, to they ultimately releasing the full couple $1 million within 6 months from now or whenever. But initially, they've only dispersed maybe a small amount. So what the coverage, when it comes to pending disbursement clauses that you'll see, it'll talk about coverage is defined as you make your disbursements in accordance of XYZ. So lender, as you disperse $100,000 or $500,000, your coverage will go up as long as you do X, Y, and Z. And so it's a little, each one of those, how that's handled is slightly different for each file. But it's connected to as the money is being dispersed. And the same kind of idea is this, something you may hear is a pending improvements. Sounds the same, not exactly on point, but sort of. And on an owner's policy, you're building a building or building a project or a house, and you're starting with what? You're starting with a vacant lot. Okay? It's worth much less than the ultimate $3 or $4 million that you're borrowing from a lender. So sometimes you'll see a pending improvement clause which says, owner, your coverage will ultimately be what, $3 or $4 million, but right now the lot is only worth, say, $100,000 or $400,000, and so as improvements are made to the lot, your coverage goes up. So these are terms that you don't directly get involved in, but you may hear about it, and the client may ask you, what is this? Why should I be discussing this? So those are the types of discussions that you'll be hearing circling around regarding these issues. One of the ones which you may get more involved in is this other one which I noted up on the screen called partial ML coverage or exceptions. And that kind of goes to, if you remember a few minutes ago, I talked about where the seller is building the building and the buyer is going to go and build like what I call the tenant improvements or the improvements inside the shell. Well, who's doing the constructing? The seller and the buyer, right? So you have this kind of this split issue of construction kind of thing. And so sometimes you'll have a conversation where the customer, the client comes to you and say, hey, I have this issue going on and the title company won't give me mechanics lien coverage, won't protect me against these liens that the seller has done, or not that the work that the seller has done to protect me against their work. And I think this is a great conversation, an opportunity for you to reach out and say, oh, well, we need to basically make sure that you're covered for their work, but maybe the title company is not willing to cover you for your own work that you're going to be doing in the future. So sometimes you have this, what I call partial, where the conversation has to be cleared up with the title company that we want to make sure that we're protected from the seller's work that they've done to risk any mechanics lien, but we know that we're not going to get protected for any of the stuff that we don't pay for, that we don't get handled correctly. So that's that partial where it can get confusing, and so sometimes that's a discussion that sometimes you have to have with the title company and clarify how it's going to be handled. All right, so those are all of those kind of conversations about underwriting of the deal and trying to assemble the information and having discussions and conversations among the parties so we can get to the same place where we get the coverages to everyone that they want and be able to close the transaction that we are trying to close. So this next one is regarding dealing with recorded mechanic liens. So it's like broken priority, like we talked about earlier. Remember I said just broken priority? Well, now we have the recorded mechanic lien. So how do you deal with that? Is this really going to be an issue? Is all hope lost for a transaction because a mechanic lien has recorded? Well, hopefully you know that that is not always the case. There are ways to get around dealing or addressing the issue of a broken priority issue where it ended up mechanic liens have recorded. Several different things. A lien discharge bond, that's a statutory type of bond which allows for a party, an individual, your client, to obtain a bond from a surety company that says this mechanic lien that has recorded, we're going to remove it statutorily from the property and attach it to this surety bond that we've gotten from this surety company. Basically, it removes the mechanic lien, the right of that mechanic lien to go after the property. Which actually brings up a good point because, you know, I didn't touch base on it earlier, but I should mention, well, once they've recorded a mechanic lien, what's the risk? Well, the risk really is that they have a right to basically foreclose on the property. If a contractor has a lien on a piece of property, they have the ability over a certain time period, you know, over several months, to be able to foreclose on a piece of property and basically wipe out a new lender, a new owner, all of those people that have thought that they've owned this property. So when a mechanic lien records, the concern is, well, they can foreclose, they can wipe everyone off this property. So that's why a lien discharge bond is so helpful, because what it does is it prevents them from foreclosing on the real estate, and they basically foreclose, if you will, on the surety bond if need be, you know, and there's litigation and so forth. So that's a good option. It is a little complicated to get done. You have, and how much it costs money and how much the bond has to be for, and there's a lot of technical applications that have to be done with the surety company, but it is a good option. Another one is, well, remember we talked about those indemnities. Is there a way to indemnify over this? Maybe it's construed as a nuisance lien and it's getting worked out, and the parties are so on top of this that they promise that they'll get it taken care of. And that could be a discussion too. And then, of course, the last one that you see on the page is to get a release. Well, of course, that's great. A release of a mechanic lien is terrific. But, as you know, I'm an attorney, so let's look at the next slide. Where there's smoke, do we have others to worry about? So if you have one mechanic lien, one of the concerns that someone who is somewhat conservative worries, are there others that could be recording? Meaning a mechanic lien records because why? Someone has not been paid. So is there potential for others not to have been paid on a project? And so those are the discussions that happen. So although it may seem successful, oh, we just got rid of the mechanic lien that recorded by getting a lien discharge bond or getting a whole separate indemnity or getting a release, or those are all great things to happen, getting it worked out. But I would not be surprised if you continue to get more questions about others on the project. How do we know that this is the only one that's out there? And so this may generate more questions if one shows up, especially at the last minute. You know, if it happened early in the transaction, it's been explained how it's been handled, and it was a miscommunication or a mistake or an oddity, a one-off, and able to get comfortable moving forward. But don't be surprised that there's going to be a discussion about this, okay? So dealing with litigation, believe it or not, it's the same or similar considerations if the litigation over mechanic liens has occurred. Litigation, well, they could start their foreclosure process, right? In the middle of your transaction, they could have recorded their mechanic lien and start their foreclosure process on the site. There could be litigation over that. There could be litigation over that the property owner has basically attacked the mechanic lien, the right to even do the mechanic lien. Basically, arguing over the issues is, no, that's not even appropriate for you to have recorded that because of X, Y, Z. You know, you did get paid, or you're not entitled to more, or any number of issues. That, you know, that's what lawyers are discussing all the time. Similar kind of questions. If there's litigation over this one or others, do we have others to worry about? What's the status of this litigation? You know, and so you'll have a lot of those kind of conversations, just making inquiries over that issue. So let's look. Okay, so does time heal all wounds? And more importantly, mechanic lien issues. So that is hopeful. Time does. I like time. Time is typically on my side because, you know, statutory, I talked about that they only have a certain number of months for them to record their mechanic lien, for them to foreclose on the mechanic lien, and those are all a lot of statutory defined terms. And so there'll be a lot of questions of when was the work done, when was the property completed, how long has it been since anyone has touched the property. There's a lot of questions that go back and forth. And so you may get a lot of those questions. But I will tell you, time does help. Because, as you can say, even from a practical, if not just from a statutory perspective, from a practical side, if no one has asserted any lien rights for months, that's a good sign, right? That means that's a good sign that people have been paid. And so that is nice to see. So sometimes we don't have the luxury of time. I understand that, but sometimes time does help. All right, well, how do we deal with the unthinkable? Well, I've dealt with this where we have a title claim being submitted regarding mechanic liens. Now, this is obviously something that's going to be happening after the original transaction is closed. So you may, and the reason I bring this up is because as soon as your transaction closes, more than likely your relationship or interaction with your past client / current client / potential future client probably doesn't go away. So if this comes up, you may be asked about this. And, you know, I'm bringing it up because just because the transaction closed and something like this occurs after closing, you may still get inquiries or questions about it. And obviously, you know, the title companies are familiar with this process and familiar with this issue. And so one of the first things that I talk about is to contact someone like myself. Although I'm not claims counsel currently, all the title companies have their claims groups to go over this, to help discuss and answer questions for you about this process. Feel free to make inquiries on behalf of your client to see what the process is and what's happening. What's going to happen after a mechanic lien is recorded after closing, or if someone starts a foreclosure under a mechanic lien after closing, or it's very varied on what will happen next. Understanding what's happening and interacting with your client makes perfect sense. You may need to get approval from the client to speak on their behalf with the title company, just so that they're communicating with you appropriately. But feel free to interact with that permission with the claims group to help you understand. So when you're talking with your client, you're understanding what's the next step. Okay, it's been submitted, so now what are we doing? Okay, now what are we doing next? How are we doing this? Because a lot of times life does not stop because a title claim has been submitted. We understand that. And so being armed with that kind of information is probably helpful for you to have, especially if a client is starting to ask you a bunch of questions. Okay, so now that time has been claimed, a claim has been submitted. Now, what do we do now? Well, obviously, we'll having to go through the process, be prepared, remember all those questions that we had in the original transaction. Well, these are going to be different kinds of questions These questions are going to be much more focused on the issue at hand. What is it at issue? Mechanics lien recorded, a foreclosure started, litigations, all of those details. It's going to be very pointed at what is in front of us today. So there'll be probably very particular questions about those issues to determine what's happening and to figure out the extent of the risk or extent of the exposure or extent of the claim at that point. So you'll have very specific inquiries being made. So, all right. So the real question here is, can you handle dealing with mechanics liens? Well, of course, yes, with the right tools and knowledge. One of the things that we're going to require is your active participation in a transaction. Your participation during the transaction of getting the client familiar with what our expectations are, to understand that mechanics lien risks are ones that have to be underwritten in a certain way, and to understand some of the statutory nuances. I know that's what a lot of the attorneys will do, but to be familiar and comfortable with explaining, well, why is the title company asking for X? Or why do I have to explain how this project is going to be handled? Some of those types of issues are what is going to be coming up, but you participating, you being proactive and part of that conversation is going to be helpful. All right, and obviously related to that, TitleMan's top 10 tip regarding mechanics liens is, think about it, it's all of the above, but the most important part of handling a mechanics lien is you. Because without your participation, I know people like myself really do rely upon you being the key to making a successful closing occur. So with that, let's look into some of the questions. All right?
Okay. So we have just a few questions for you, John. So the first one is from Richard. And is an HOA lien considered to be a mechanics lien?
No, it's not. It has its own types of priority issues and foreclosure issues, but it is something that is not, it's not the same extent as mechanics lien issues because it's very narrow in scope, but they have very special ways of handling those. Okay?
Okay. And then Terry asked, is there a minimum amount for a mechanics lien?
No, there isn't. And sadly enough,
Wow.
You could have a couple $100 mechanics lien, or you can have a couple of $1 million mechanics lien. And, you know, as I discussed before, the amount is important to know, but there could be more at issue depending upon the rest of the project. So I wish you could have a threshold of an amount, but I don't have that, unfortunately. Sorry.
Wow. So any type of unpaid bill out there, a $10.
Well, I'd be surprised they're going to do the $10 one because, okay, first off, most people don't hire a contractor for $10 worth of work. You know, so more from a practical side, you'll see a number of some significance, because usually those smaller types of projects are not really the ones that you run into issues here. It's larger amounts, you know, a couple of $1,000s, 10, 20, whatever. Those are the ones that'll be more at issue.
Okay. So, and then Jenny asked, do subcontractors only have 6 months to pursue a lawsuit before it expires once it's recorded?
A mechanics lien claimant has 6 months from the time it's been recorded to complete their foreclosure.
Okay, excellent. And then Clifford asked, what's the difference between a mechanics lien that had a 20-day pre-lien notice filed and one that was filed without a 20-day pre-lien notice?
Oh, that's a great question.
Somebody sounds like he knows what he's talking about.
That's a good one. Thank you. Yeah, what he's bringing up is this issue of a preliminary 20-day notice, which the statutes talk about basically warning the borrower that we have a right to lien on this property, and this is the information about who you are, who we are, what the contract is for, etc. And the preliminary 20-day notice is basically a notice that's provided from the contractor to the borrower, basically, to let them know what's happening, but also to let other parties know that, hey, we're doing work on this property, and so we're going to be claiming a right if we don't get paid for lien rights. Now, the question is say there's someone who didn't do a preliminary 20-day notice, and they've recorded a lien. The question is, how far back can they look? And guess what that magic number is? It's typically 20 days back. So if you did work 50 days back, you wouldn't be able to collect for that amount. But for the 20 days back, you could. So it gets complicated. You know, how do you know what was 20 days, how much was 50 days, whatever. But yeah, with or without a preliminary 20-day notice impacts the amount of recovery by the lien claimant.
Wow, that's a great question. Okay. If the subcontractor doesn't follow through to foreclosure, does the lien just fall off?
They lose their ability to foreclose. So the question comes is, well, if it's out there after those 6 months, what happens to it? Well, you're not going to get a release out of them. You're not going to get something of record. The whole question is it valid anymore? And there's some other questions about how do you extend that 6-month period, or there's other lawsuits. It gets complicated if you have a big complicated transaction, but in general, if they have not if they have not started a lawsuit within that time period, they lose the ability to. So it's just basically it's an invalid lien at this point, or expired. That's probably a good word for it.
Okay. And then, let's see, great, thank you. And then we have this question here.
Yeah, so one of the other questions that came in early on was, is the difference between a residential project and a commercial project on who can bring a lien, whether it's just the generals or the subs, meaning a general contractor or subcontractor. And really, other than there are some special protections for an owner-occupied, like an owner building their own house type of thing, where there are certain requirements regarding direct contract requirements. There's generally no real difference from a residential commercial project on these people being able to lien a property, whether it's a house being built or a commercial project. It just gets more complicated when you're dealing with a commercial project, likely. So
that makes sense. Well, thank you very much, John. Any closing remarks, any words of wisdom you want to share with our listeners today?
Well, I am just so excited. I'm really glad to be here today, and this was a great topic for me to talk about. I loved it. Thank you so much for having me.
Well, thank you very much. And folks, as you can see, John's contact information is on the screen for you. Best way to get a hold of you?
You could just track me down through the email right there, right on the screen. That's the best way to reach me.
So Titleman at askthetitleman.com.
That's right. And you can even Google me. You'll find me.
No worries. That's what I did.
Oh.
That's what I did when we had a couple of people who recommended you for a presenter. I was like, I don't know this person. And I Googled you, and wow.
And you still invited me.
And I still invited you. Absolutely. And thank you so much for joining us today, John. We appreciate it. And folks, thank you very much for joining us today, and thank you for your questions. John's handout was emailed to everyone if you were able to register before like 10 o'clock this morning. Otherwise, we did upload it into the system, and you can download it to your computer before you log off today. Well, thank you very much for joining us today, folks, and we will see you on our next one, which is coming up on March 15th, which is part 2 of our buyer counseling session with Evan Fuchs. So thank you very much, and have a great day.